Counsel, you can take your time getting up here. We'll wait till the courtroom clears before. You may proceed whenever you're ready.
Your Honors, Holly Van Horsten here on behalf of the Federation of Public Employees. May it please the Court. Today before us, we have two main issues, which I will examine both in turn. The first being discrimination against the Federation Director of the Bargaining Unit, as well as Federation Representative Lisa Zarazinski, for protected activities in violation of 447-501 1A, B, and D. And with respect to this particular issue, the appellant alleges that there was a violation, an error in an erroneous interpretation of the law with respect to this issue, and that there was a misapplication of the law to the facts. Secondly,
let me ask you a question.
Certainly.
The collective bargaining agreement the parties were operating under when this cause of action arose expires in 10 days, in September 2010, as I understand the record. Is that correct?
With respect to the expiration date, I believe that's the case.
Do you know whether there is a new agreement in place at this point?
I have not been necessarily retained to negotiate that particular agreement, so I'm unaware of that answer.
Well, the reason I'm curious, obviously, is the order or the recommendation that the hearing officer made, as I understand it, was simply told the sheriff's office to go back to the way it was before you took this action. And so I was just curious if the parties have gone back to the bargaining table and come up with a different set of circumstances that is going to govern their relationship in relation to bargaining unit representatives. It almost seemed like, what relief can we grant at this point?
Well, the appellant would advance that that certainly would be the time in which both parties could discuss the situation with respect to the leave issue as far as bargaining goes. Because with respect to the first issue as far as the violation of law which occurred, in essence, the Commission in its final order short-circuited the analysis present in Pasco County School Board with respect to analyzing a violation for discrimination. Essentially, what the final order stated was that regardless of motivation, that Broward County Sheriff's Office was permitted to take that action. But that goes completely against the analysis set forth in Pasco County School Board. The first prong, in essence...
Well, does it? I mean, isn't there, even before you get into the question of whether there was protected activity, that action, I mean, don't you have to have adverse action taken against you?
Well, with respect to adverse action, Pasco County School Board does not state explicitly in its analysis that the action itself needs to be adverse. Furthermore, the action was adverse to the individuals present in this case. There is no explicit analysis as to whether the action constitutes adverse or doesn't constitute adverse. Furthermore, it
was only adverse because they were, I don't want to say acting under, they were working under terms and conditions that were inconsistent with the CBA. Is that not right?
The individuals, both the bargaining director as well as Lisa Zarazinski, interpreted the action to be adverse because it was a change in their schedule that was sudden and dramatic and in fact had impacts on both of those individuals' lives. And so when viewing the action, it's viewed within that analytical structure where the first prong is to establish protected conduct. And after that's done, you then look to determine whether that protected activity was the motivating force for the decision by the employer. At that point, the burden then shifts, and it's the employer's...
So in your view, it doesn't matter if, for example, somebody was in the collective bargaining agreement required them to work 40 hours a week, but through the grace of their employer, they'd only been working 30 hours a week for the last 5 years. And then a new boss comes in and says, nope, everybody in this office has got to work 40 hours a week. I mean, obviously, as to that person who's been working only 30 hours a week, working an additional 10 hours would be sudden, dramatic, a change of conditions, but it's requiring them to do no more than has been bargained for. So I'm struggling to understand how we even get to the analysis in Pasco County without something that takes away a right that is in contract.
I certainly understand, Your Honor. However, the issue is that, of course, the employer can go back to the contract language. They're certainly entitled to do so at any moment in time, absent anti-union animus.
Okay, so you're conceding that they don't have to go back and rebargain. But your argument is that you still can't take an adverse action as to a particular employee based on protected activity. That's how I understand your argument.
If there is, in fact, right, the anti-union animus that's present in a discrimination context. So specifically, yes, that's in fact what we're advancing, that the ULP, the unfair labor practice, many of the actions that employers can take may not be considered to be explicitly adverse. However, they are entirely adverse in the context, which is why the court looks to see whether the decision was made as to that action based on the protected activity, based on whether or not those individuals engaged in protected activity and whether or not that protected activity was a motivating factor for that action. And then philosophically, wherein lies the analysis as to the balancing of interests between the employer and the employee is after that burden shifts. Once, in fact, that burden shifts, then it's the employer's responsibility to say, well, in essence, we're simply returning to the language of the collective bargaining agreement, which in fact it did. However, there was no other reason that they advanced as to, they being the Broward County Sheriff's Office, they advanced as far as why they returned to that language of the contract. And furthermore...
Well, why, I guess I still can't get over the thing, I mean, in legal terms, so what? I mean, it's obvious from the record and the findings the hearing officer made that the reason the sheriff went back to the CBA was because he was unhappy with the union. I think they haven't contested that on appeal. It's obvious on the record. It makes common sense, but so what? I mean, your clients or the individuals in this case are no worse off than they would be if they were acting pursuant to the bargaining agreement throughout the course of things. I guess I'm just still not understanding what the adverse action against them is. I mean, they're not entitled to rely upon continued practice contrary to the CBA, are they?
No, but when it comes down to prohibiting the discriminatory conduct with respect to an individual's protective conduct, that is really the essence of an unfair labor practice. That the employer cannot engage in discriminatory conduct, i.e. the fact that the other bargaining units within the Broward County Sheriff's Office were not required did not have their policies changed with respect to union leave until, in fact, the unfair labor practice was filed and or grievances were filed. And so it's, in essence, a prohibition, as the law establishes, on discriminatory conduct directed towards employees on the basis of their protected activities. And then speaking more specifically to your question with respect to employee representative Lisa Zarazinski, her status as an employee representative, the number of hours that she could work in terms of union release or she could perform was never explicitly addressed by the contract, which brings us to the second...
What did she specifically lose here?
As far as what she lost?
Yeah, what was the sheriff's actions again?
With respect to Lisa Zarozinski, she, on a Thursday, received a call that the next Monday she would have to return immediately to her schedule, as far as she previously was a full-time Federation representative working on behalf of this particular bargaining unit, which contains 3,000 members. And in fact, there's quite a bit of work to be done on behalf of the bargaining unit. And so, in addition to that,
But the collective bargaining agreement didn't provide she was a full-time.
the collective bargaining agreement did not address the number of hours that she was permitted to have as far as leave goes as a Federation representative. The collective bargaining agreement addresses...
Didn't the CBA actually say you get one representative, and that representative gets 12 hours per, whatever it was, week, month, I don't remember the terms. I mean, so it specifically addressed the issue of how many, how much regarding representatives, didn't it?
Only with respect to the director of the Federation's bargaining organization, which is embodied in Article 14.5. The Article 14 also permits leave for union representatives in addition to the director of the bargaining unit. And it specifies where the representatives, what particular facility they can be a part of, how many there might be, but it makes no mention as to the number of hours that those representatives are specifically permitted. In fact, it makes no mention of the hours with respect to any representative besides this director.
Well, doesn't all this, if I understood, the bargaining agreement's been in place, or that provision of the bargaining agreement's been in place since the mid-'90s. I mean, doesn't it make sense for this dispute to be worked out at the bargaining table? I mean, if your client truly believes they need two people full-time doing bargaining unit activities, I mean, shouldn't that be negotiated at the bargaining table rather than, trying to go through some litigation process when all the sheriff's doing is saying comply with the bargaining agreement?
Your Honor, I believe ultimately it should. However, what happened in this matter is that there was discriminatory conduct which occurred towards the Federation, which completely changed the game. Absent that, they would have been able to quote-unquote, revert back to the contract language. And in fact, come next session of bargaining, they can address that topic again. But there is a prohibition.
Let me interrupt, because I just found the language and I found it. She was been issued a vehicle and a computer as the full-time employee rep.
Yes, that's
those
correct.
taken from her as well?
That's correct.
Okay, and it's going to go to some questions I'm going to ask the other side, but okay, yeah. That's what I was asking you earlier, about what action was taken. I didn't think it was just that she was no longer the full-time union rep, but stuff was taken away from her as well.
That's correct.
Okay.
She didn't lose any salary, did she?
No.
So all that was done was she lost a vehicle and a computer, which I'm assuming are not provided to other sheriffs. Do we have any record evidence as to whether other deputy sheriffs get this and she now doesn't? Or did she only get it because she was acting as a bargaining unit representative?
It was a part of her duties as bargaining unit representative. However, when contemplating the direct action that was taken, it was the change in schedule, and a retaliatory one at that, which was the true nature of the action taken against both her and the director of the bargaining unit, which at one point was Mr. Fenoy and then succeeded by Mr. Marciano.
So if we were living in a hypothetical world and the sheriff was not unhappy with the union for the actions it took and supporting his political opponent, if he just came in one day and said, you know what, Ms. Sarkinski, I just really don't like you, I don't like something, non-union related, nothing like that, and said, you know what, I've been looking at the collective bargaining agreement, and you're not supposed to be doing this, and so Monday morning I want you back on the job in uniform, answering phones, or whatever role she got. That would be fine and dandy. It's the anti-union animus that you have a problem with?
Well, with respect to a violation of the law that we're dealing with presently, the issue with respect to the law is that they can't engage in that discriminatory conduct as far as 447.501(1)A, B, and D. So as to the legality of that issue outside the union context, I can't specifically speak to that. However, it is true that the anti-union animus present in this instance is what I suppose, in essence, elevates the conduct to be discriminatory and in violation of the law.
Okay, you're down to about a minute and a half. I'll give you about 2 minutes for rebuttal if you'd like.
I'd like to reserve the rest, yes. Thank you.
May it please the Court. Good afternoon. My name is Dina Sokolow on behalf of, from Allen Norton and Blue. This is Shayna Brenner on behalf of Sheriff Alan Birdie and the Broward County Sheriff's Office. I wanted to first address a question that you posed to opposing counsel that I think is very pertinent to this case. A new contract was ratified, the successor contract.
Is that on the record?
Yes, it is in the record.
It was on the record? Okay.
Yes, it is. It is, Your Honor, in March of 2009. And the reason that I find that that is significant is because the change that was made with regard to release time was made in February. So the parties had an opportunity to negotiate this before they ratified the contract with the same exact terms. They had an opportunity to negotiate this knowing that the sheriff was going to enforce the terms.
Would you agree with me that you can do certain things? The sheriff has the right, or an employer has the right to do certain things, but if they do it in retaliation for union action, that's a problem?
Your Honor, I do agree with you, but not with regard to enforcing the contract. I don't believe that even enforcing a contract with anti-union animus is considered an unfair labor practice. I don't believe the cases say that.
Okay. Clearly, when you say enforcing a contract,
Right.
I think everybody agrees. I don't think the other side argues with you that if you change the terms of conditions of employment but go back to just what the contract says, that cannot be an unfair labor practice.
Right.
How about a situation where a employer says, been doing a good job, and this is happening in a police context, I'm going to give certain police officers here a car to go home. They can take your car home. I'm going to pay the gas because it helps. The union contract might not even say that, but I'm going to allow certain deputies or certain ranks to take their car home. And one of those deputies or one of the people that I give the car to, this person is advocating a new union contract. He is really being a pain in the neck. He is just doing all kinds of union activities. And I come in and I say, hey, I am sick and tired of your union stuff. I'm going to let everybody else have a car, but you lose your car. Could that be an unfair labor practice?
No, Your Honor, I don't believe it could.
It couldn't be.
And I'll tell you why. Because if you look at 447-501, it specifically enumerates the protected activities that are protected. And receiving a car is not a protected activity.
Okay, but the protected activity we're talking about is the union activities.
Right.
Not the right of having a car. So that's the protected activity is something else. The hearing officer specifically found that there were protected activities that were involved here.
They did, Your Honor, but what perks? I'm sorry. Go
Okay,
ahead.
but let's assume for a second that they're protected activities. You are
Okay.
being punished for
For
doing
protected
something that
activities.
the statute is intended to protect. Let's make that assumption first.
Okay.
Then the question is, can there be an adverse employment action on the basis of that? Now, the contract didn't guarantee these people a car.
Right. I understand what you're saying. I believe,
And the
I believe
public,
there
it seems to me the public policy behind 447 is to allow these people to conduct themselves for union activity. And that somehow, if you take away the employment benefit that they had before, you are discouraging union activity.
Your Honor, in the scenario that you just posed, I think that you could find an unfair labor practice. But I think when you're talking about the purpose of Chapter 447, we need to look at the expectations of the parties. And what is the reasonable expectations of the parties? When you have a contract that's in force and effect, it's got to be the terms of the contract.
Can there be an adverse employment action for something that is not specifically addressed in the contract?
I believe there can be, but I believe when the contract, I don't believe that there can be an unfair labor practice when you are requiring a party to adhere to something that has been negotiated and decided. And that is the case here. This has been negotiated. I'm sorry, go ahead.
No, go ahead, finish your thought.
Well, what I was about to say is their argument that this wasn't addressed in the contract is really
Okay, I'm giving you a card to everybody that doesn't support the union. Sheriff says that.
You're saying that if they give a benefit versus an adverse action, if
Yeah.
it's just an action.
Is that an
That
unfair
is to
labor
the
practice?
to the
Is that a
detriment.
violation of Chapter 447?
If they give it to every people who doesn't support the union and who does, and you're saying that there is a protected activity.
Yeah,
Yeah, I understand what you're saying. I understand.
where does this stop? I mean,
Well, I understand what you're saying, but
if you're doing something for a purpose that is purely intended to subvert rights guaranteed by 447, shouldn't there be a remedy for that?
Well, I think there should be, but I think I believe there is a distinction when we're talking about enforcing a contract. I mean, the basic premise of the collective
Is the
bargaining.
unfair labor practice here that the contract was violated, or the unfair labor practice was that this person was being punished for conducting protected activities under 447?
Well,
I don't think we're talking about a violation of the contract. I agree with you.
No, I don't think we're
I
talking
agree
about.
with you. There can't be a violation of the contract.
Right.
And I agree with you that that clearly the sheriff would have a unilateral right without negotiating to go back to the contract. I mean, I think that law is clear. But I'm getting hung up here where something is specifically done with animus.
Well, first of all, I wanted to address, I think Judge Weatherall mentioned it in opposing counsel's argument, that we concede that there was animus. We don't. We don't concede that there was union animus. In fact, I don't think that the record establishes that there was anti-union animus. What the record establishes is that possibly that the sheriff was disappointed and frustrated with the fact that the FOPE supported his opponent. But frustration.
I go to page 14 and 15 of the recommended order, and I'm not going to cite it, but
Right.
it seems pretty darn close that the hearing officer, who's the factual finding here, determined there was some animus going on.
Well, right. He comes close, but he doesn't actually make the finding. And what is interesting, though, is if you look at it, in the terms of collective bargaining is rough and tumble and a lot of times adversarial. And there's many times when an employer or an employee is frustrated with or unhappy with something the other side is doing. And an employer might be frustrated because the union is putting forth a position they don't feel is in the best interest of the employees or the best interest of the public.
Is the picketing
The informational
protected
picketing?
activity?
The informational picketing?
Yeah.
Well, we would argue that it's not in this case because we believe that the informational picketing was purely political.
Well, let me ask you this and go back to where I started this. If the charge was brought based upon actions taken in February, the parties went back to the bargaining table and came up with a new agreement that is consistent, if your representation, consistent with the old agreement, therefore making it abundantly clear that whatever past practice might have glossed onto, in their view, interpreted ambiguities in the existing, no longer exist. How can we, or how can anybody enforce upon the parties a obligation to go back to something that they bargained away?
I don't believe they can. I don't believe they can.
So your argument, maybe I'm hearing it for the first time today, is that this case is moot.
It is moot. It is moot because the parties ratified the contract in March with the same language and this language has been in the contract since 1995. I mean, there should always be an expectation among employees, and I think there is a plethora of case law on this, that the expectations of employees should be what they negotiated and agreed to. This was negotiated and agreed to. It's very explicit language of what we're talking about. Release time.
Is the case moot, though, as far as the arguable remedy here?
Right.
But the fact that the sheriff violated Section 447 and sending a message to that sheriff that he shouldn't be doing that, is that moot? I mean, because it seems to me that you have two things going on here.
Right.
I mean, one is the remedy, but number two is the question of, there is a case out here that seems to be saying, Sheriff, you didn't do anything wrong.
No, I understand what you're saying, but I think, though, that the fact that they sat on their right to change or try to negotiate the contract to change that language makes it moot.
So I guess the point would be, and I understand, maybe Judge Wolf's got a point there, but if the relief they're asking for is for us to reverse PERC's order and require PERC to adopt the recommended order, that recommended order directed the sheriff to cease and desist from terminating for reasons attributable to unlawful union motivation, blah, 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 its prior oral agreement with the Federation to allow paid full-time employees, blah, 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 take the following affirmative action, reinstate its prior policy of allowing full-time paid. I mean,
Right.
To me, if the parties have bargained
Right.
and now have, eliminated this ambiguity, I just don't know how we
Basically,
could order
enforcing
that.
the hearing officer's order would be saying that they could orally change what they've negotiated and ratified in the terms of the contract. One of the things that is interesting about, besides the fact that in March that they ratified this, we were talking about the motives and I think you were saying that you thought that there was very close to a factual finding that there was anti-union animus, but when opposing counsel was talking about the other unions, she actually misstated the record. What the record shows is that they were notified on February 16th that they were going to be required to adhere to the contract. Now, the timing of this is interesting because what happened was right before that, the person that had been in the position had announced that he was not going to be for personal reasons, couldn't be in the position anymore, and they were going to replace him with another sergeant. So the union actually brought up the subject. They came to the sheriff and said, we've got another sergeant who is working 40 hours a week on behalf of the Broward County Sheriff, and we want you to now put him into the position, pay him full-time to do union activities. And at that point, that triggered the sheriff notifying them that he was going to make them adhere to the contract. And as to the other two, the PBA and the IAFF, the record shows that in March, the PBA was required to adhere to its contract. This ULP was not filed until May. And they claim, well, you didn't change the PBA until we complained about it. Again, to quote Judge Weatherall, so what? How is that anti-union animus? They're saying we treated one union better than the other two unions. I mean, the fact is that we have enforced this for all three unions where the two other unions didn't engage in informational picketing, didn't file a ULP, didn't file grievances in the beginning of February, didn't engage in the conduct that they're claiming formed the basis for the reason we are enforcing it against them.
So you would argue, and looking back at the final order and the recommended order, I mean, PERC says that assuming for the sake of argument, Lamberti was retaliating for political activities, filing grievances, et cetera, his motivation is immaterial. I think they mean irrelevant, but in any event, I have interpreted that as accepting the hearing officer's finding, but you're suggesting to us that that finding, which says, in effect, cumulative evidence, generally unrebutted, was that the sheriff resented the Federation's endorsement of the opposing candidate, that he questioned whether he engaged in negotiations. That is not a finding of anti-union animus.
No, I don't believe it is. I don't believe it is. And if you look at, when we're talking about the prima facie case for finding under 501(1)A that there was interference with or coercion or restraint of an employee's exercise of their rights, they haven't identified where that happened. Where is the restraint of their rights? They still have a right to file grievances or declare impasse or to negotiate. Removing release time from two full-time employees doesn't prohibit that. They still are allowed under the terms of the contract to have a person designated for 12 hours a week up to 16, and 30 other representatives who are allowed on the sheriff's dime to process grievances, attend meetings, and attend collective bargaining sessions.
How do we deal with the hearing officer's finding? I know you're arguing that that the action taken against the other unions was about the same time, and it wasn't in response to this. I read the hearing officer's findings to be that the change made to the other unions was indeed precipitated upon what happened here, looking back in page 10, finding 17.
Right. Well, what the hearing officer says is that because they complained, the change was made, and then after the ULP, the change was made for the other union. So he's saying that the fact that they complained about it, but I don't think that that's a protected, I mean, he's saying that the fact that, I mean, he acknowledges that it was changed before the ULP was filed for the PBA.
As I read that, basically what he was saying was the sheriff's trying to cover his tracks.
That's how I read it, too.
But, well, I
still get to, so
I'm out of
what?
time if you let me respond to that. That may have been his interpretation of it, but the fact is that all of the unions are required to comply with this, including the ones who did not.
But you didn't take exception to his finding that the covering his tracks implication that was made.
Well,
that he wasn't going to change.
The ULP wasn't filed until May. The ULP wasn't filed until May. So we made the change in February, and maybe they brought it to our attention, and they said, what are you doing with the other ones? We wrote them back and said we're going to enforce it with the other ones. And then in March, we enforced it with the PBA and with the IAFF. For whatever reason, it's not in the record, but it took until June. But you can't say that it was all precipitated on covering their tracks because no ULP had been filed yet. It wasn't filed until May.
Okay,
Thank you.
Your Honors, in response to the appellee's contention that there cannot be a ULP with regard to enforcing the contract, that is certainly not what the case law states. In fact, with respect to Local 1222 NCF&O versus Pinellas Transit Authority, it specifically addressed the issue of union leave, and that the parties could return to that contractual language where there was no allegation that union leave was denied because of anti-union animus, implying that if anti-union animus was present,
implying but not holding, correct?
Well, it was directly addressed by the court. They said, and additionally, no anti-union animus was found, which directly aligns with previous holdings that basically confirms that when there is anti-union animus, if the employer is otherwise lawfully able to engage in that action, it can still be considered an unfair labor practice.
How do you respond to the contention that there's no relief that can be granted in this case in view of the fact the parties have now negotiated, gone to the bargaining table, and apparently readopted the policy that was in place before that now we know does not include multiple employee representatives? How do you respond to that argument?
Your Honor, I would assert that the employer and union's contract negotiations is completely separate and apart from the discriminatory conduct engaged in here in this present instance by the sheriff. And we simply cannot give the sheriff and the Broward County Sheriff's Office a pass because there was subsequent contract negotiations where that very contract provision was ended up being as it was, particularly in the present contract and the matter at hand.
So no matter what the contract says, forever and ever, they're entitled to have these two full-time union representatives that are paid a salary to be deputies while they're doing union stuff?
I would certainly say no, Your Honor. I would say that essentially this, if action and relief was granted as far as restoring those two individuals to full-time release, that they would be entitled to that full-time release until the next section of contract negotiations.
Okay.
Thank you.
Being no further cases in front of the court.